Moving on to the rights of the accused and the rights of criminals, we're going to look at the 4th through 6th Amendments, as well as the 8th Amendment. I'm going to power through a few cases here, talking about the rights of the accused and the rights at trial. This obviously isn't intended to be a complete list, but it does give you a history of some of the most major cases that people should know, and a history of the incorporation of the laws here. The 4th Amendment addresses the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. It assures them that no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So our first case here is Mapp versus Ohio. The details of the case aren't necessarily very important here, but the basic idea is that the police obtained evidence against Mapp through an illegal search of her home. The Supreme Court argued that this evidence could not be used in a court of law because it was illegally obtained in violation of Mapp's 4th Amendment rights. As such, it was excluded from the trial, as was any evidence obtained as a result of finding the illegal evidence. This principle is known as the exclusionary rule and gives people meaningful protection against illegal searches. The 5th Amendment also provides protection against self-incrimination and being tried for the same crime twice, also known as double jeopardy. The big case here is Miranda versus Arizona. In this case, the Supreme Court considered the constitutionality of a number of instances in which defendants were questioned while in custody or otherwise deprived of their freedom in any significant way. The question is whether people can freely give statements to the police while in custody, or if the fact that one is in custody implies a lack of consent. The court ruled that statements given while in custody are considered involuntary unless the person is explicitly advised of his or her constitutional rights. You may have heard of the Miranda rights, the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be provided to you, etc., etc. You hear them on sort of the TV shows all the time. These came from that case, and the idea is that you have an affirmative right to understand your rights before speaking to the police. The next amendment we're going to talk about is the 6th Amendment. This includes the right to a speedy trial by an impartial jury and the right to counsel. The big case here is Gideon v. Wainwright. Gideon was charged in Florida State Court with a felony. When he appeared in court without a lawyer, Gideon requested that the court appoint one for him. According to Florida state law, however, an attorney may only be appointed to an indigent defendant in capital cases, so the trial court did not appoint one. Well, the Supreme Court was presented with a case and asked, does the 6th Amendment provide the right to counsel in all cases? In a unanimous decision, the court said yes. The right to put on a defense is considered so important that the courts ruled that indigent defendants are entitled to a lawyer in all criminal cases. Finally, we're going to talk about the 8th Amendment, which is the prohibition against cruel and unusual punishment. The big question here is obviously whether the death penalty constitutes cruel and unusual punishment. In the first case, Furman v. Georgia, the court asserted that the death penalty was in fact cruel and unusual, although there were several concurring opinions with the court being unable to agree on any single rationale for their decision. One important case here was that Furman was sentenced to death for an accidental killing. He was burglarizing a house, tripped and fell, and in the process shot and killed a child. The courts have pretty consistently asserted that the death penalty is only an option for things like premeditated murder or other aggravated murders. Lesser crimes aren't eligible for the death penalty. The next case we're going to discuss here is Gregg v. Georgia. In this case, the court overturned the decision in Furman and decided that the death penalty is legal provided that certain procedures are undertaken to minimize issues with fairness. The big one here is a bifurcated trial. A bifurcated trial being one with two separate parts. The first part is to determine guilt. The second part is to determine punishment. Does this person receive the death penalty? As of this recording, this is the controlling case today. The death penalty is legal in every state that wants to have it. States have different rules on that. But there's some shifting in public opinion, some recent errors, shortages in the drugs we use for lethal injections that have made some executions brutal, difficult, etc. So we may be heading toward a change. It feels like we're kind of shifting in that direction, but I wouldn't count on it anytime in the very near future.